Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer. We're going to look at a case decision involving tax resolution. And this is actually a lawsuit, which we don't see too often with back taxes, but it's a lawsuit brought by the federal government against a couple of taxpayers. And here's the key learning point. We have to understand the CSED, C-S-E-D, which is basically statute of limitations in tax cases. And you'll see this is from just a couple of weeks ago in district court actually in Alaska. And so it's a little bit unusual. The defendants, who are the taxpayers, moved to dismiss the case, and the plaintiff, which is the government, moves for summary judgment. And so why did the government bring this case? Well, they bring it because they want a judgment against the taxpayers so that they can then collect the taxes. And again, this is not real common, but we do see it. And it's just so critical to understand about statute of limitations. We see lawyers that don't understand it, CPAs that don't, enrolled agents, going back to lawyers. You'd see bankruptcy attorneys not understanding about this, and they may file bankruptcy when they shouldn't, and otherwise the taxes might have gone away. And so there's just really vital, if we're involved with back taxes, we must understand about statute of limitations. So basically we have this company, they failed to pay some payroll type taxes. And when you do that, the government says, all right, whoever's individually responsible for that at the company, and that could be multiple people, but they say, now you're personally liable for that. And there are all these penalties. And then this couple here is also, they filed joint tax returns and they did not pay their taxes. So they have all these assessments. And first we have this motion to dismiss. And the taxpayers offer 4 reasons, none of which are accepted. Number 1, their work days have been cut. Well, that doesn't affect whether or not they owe the taxes. Number 2, they say the COVID-19 pandemic is very scary to them. Well, that's not a basis. Number 3, they're both over 60, and so their risk of catching COVID goes up. Well, again, that's not a basis to throw a case out. And then number 4, they say, look, convicted felons are being let out of jail because of COVID, so you should cut us some slack. And the judge says, I reject all those. So the government, we'll just call it the IRS, is technically United States of America, but let's just call it the IRS. The IRS is moving for summary judgment, saying there's no reason to have a trial, just summarily enter judgment in our favor. And so the court points out, well, when one party moves for summary judgment, the other party gets the benefit of the doubt. If you have facts that could kind of go either way, you go toward the party that's not requesting summary judgment. That would be the taxpayers here. And the court points out the government bears a burden of proof that the taxes are actually owed. And normally they introduce the assessment of taxes, and that's enough. And that's what they did. So first we start off with, we'll just call them basically payroll taxes. This person was the sole proprietor of this contractor, and so all these taxes are going to be imposed against this individual personally. And you can see there's also penalty. So it's $41,000. And then we have just the personal tax returns, and those add up to $37,000. And the judge says, look, the burden now shifts to the defendants, the taxpayers, to show those assessments are wrong. And basically they have 2 arguments. Number 1 is, hey, we paid money and that's not reflected. It's a pretty good argument. And they say, look, we paid this money and our PFD, which is basically the annual money that people who live in Alaska get, and that has been either paid voluntarily or diverted to the IRS. And it adds up to a little under $8,000. And the IRS says, yeah, you paid that, but that's not what we're suing you for. In other words, the money you paid went to other tax years, other tax assessments. What we're suing you for, you don't get any credit for that money because it's already been used elsewhere. And the judge agrees with that. It says defendants have received credit for the payments to which they cite, so they've not shown that there's any issues of fact, that's the test under summary judgment, as to the amounts that have been assessed against them. So here's their real argument, and this is why I'm bringing this case to your attention. They say, look, statute of limitations bars most of the collections that the government's seeking. So here's the rule. You must collect the money or get a judgment. In other words, start a lawsuit. So let me rephrase it. You have to either get the money or start the lawsuit, which would ultimately lead to a judgment, within 10 years after the assessment of the tax. That's critical. We're not talking about, well, hey, my 2012 taxes, they have to collect that or sue me by 2022. No, it's the assessment. Maybe I didn't file my 2012 taxes, or maybe the government went back and revised them and they made an assessment in 2014. Well, then it would be 10 years from 2014. So that would take us 2024. So the court says, well, look, March 2008, that's when we have the earliest assessment. So statute of limitations would run in March 2018, and that's before the government sued. So pretty good for the defendant. But the 10-year statute of limitations period is suspended. In other words, if you think of like clicking a stopwatch and you got 10 years, well, there are things that happen that cause the stopwatch to stop. Okay, it's no longer ticking. So the period is suspended for the period in which the IRS is prohibited from making a levy. So here's the basic concept. There are things we can do. We can file bankruptcy. We can do an offer and compromise. Any number of things that will prevent the government from being able to collect against me. Well, if the government can't collect against me, then it makes sense that that stopwatch is going to be stopped. Okay? Because otherwise that would be unfair if, they have this 10 years, but let's say for 5 years of that, they're not allowed to collect, but yet that time period's still running. And so the government says, well, look, here's the rule. If we can't collect against you, then our time period is not running. So the IRS cannot levy a tax while an offer and compromise. And we have a video on offers and compromise. It's basically you owe this much, but you come into the government, the IRS, and say, how about you take this much right here? Let's compromise. So I'm making an offer that we compromise, that we bring down the amount that's owed. So the IRS cannot levy a tax while an offer and compromise is pending and for 30 days after the rejection or appeal of the rejection. So an offer is pending beginning on the date the IRS accepts such offer for processing. And so, going back up here, thus statute of limitation tolls while an offer and compromise is pending and for 30 days after the rejection. So it's undisputed that statute of limitations was told by a pending offer and compromise from October 2017 to November 2018. So you add 30 days to that, and it comes up to basically 13 months. So the government says, hey, look, statute of limitations did not expire until April 2019, and that means our lawsuit was timely because we sued you in March 2019. But the defendants, the taxpayers say, whoa, not so fast. We got some help from the Taxpayer Advocate Office, which is a government office, and they're supposed to help you as a taxpayer. They say, look, the collection statute expiration date, that's where you get the CSED, CSED. So collection statute expiration date. For many of the tax liabilities are expired. So here's a handwritten chart that they got from this Taxpayer Advocate, and it lists the fall-off date. And that's just an expression that the CSED falls off. So it's too late for the government to do anything. And so you can see 2017, here's one in 2019. Well, the lawsuit was filed in March 2019, so that would be fine. But this one would be gone, that would be fine. So some of these would be gone and some would be okay. And the court says, first of all, some of these tax periods, it's irrelevant because plaintiff, the government's not attempting to collect for those tax periods. And even if the dates are correct, what the chart shows is the collection efforts were timely as to many of the tax periods. So we can even see up here, remember it's filed in March 2019. Well, that would be fine, that would be fine, that would be fine. And then it says, look, there's really two time periods that are at issue. The 2006 1040 and the 2005 civil. And so this chart says, well, it would be too late because 2018. But the court points out, remember, it's not when you file the tax return, it's when the tax is assessed. So the date on which the tax assessment was made. So the 2006 tax period, the assessment was actually made July 2008. So if we go July 2008, we add 10 years to that, and we add that additional basically 13 months for that offer and compromise. So that takes us to August 2019. They filed in March. So I've talked about this in other videos. You should only file an offer and compromise when you legitimately and from an educated standpoint, you are really confident it will be accepted. Because here's the danger. While that thing is pending, your time period stops. Okay? So it would have been too late for the government, but remember, we've got that additional 395 days, which is about 13 months. And so that made this lawsuit by the government timely. And then there's the civil penalty. And they say, look, it would expire January 2019. But they say, look, that was actually assessed November 2008. So 10 years takes us to November 2018. But then you have to add that additional 13 months. And so that really gets us to December 2019. This was filed in March, so it's fine. And so the motion to dismiss is denied, and the government's motion summary judgment is granted. And so it's $41,000 plus $37,000. And so again, the point of this is to just stress to us, if we're going to fight with the government, if we're going to make decisions, should I do an offer and compromise? Should I file bankruptcy? Well, I have to know the CSED, the statute of limitations. What makes it sort of complicated is every year, every tax year, it may have a different CSED, a different statute of limitation. And it depends on the assessment. When's the assessment made? And have I done anything to stop, or sometimes this is called to toll the statute of limitations. You can just think of it as freezing or stopping the statute of limitation. And if I have, then if I'm thinking about an offer and compromise or this or that, that might also stop that time period. Is that smart? Look, sometimes we look at these things and we say, oh my goodness, we're like 2 weeks away from maybe $30,000 of tax liability just falling off, going away. So maybe I don't want to do an offer and compromise at that point. Give the government all this extra time to go, oh my goodness, this thing's about to fall off. Let's take some action as soon as the offer and compromise is rejected, if it's rejected. So we just have to be strategic about this. And the only way to do this is to understand for each year's tax assessment, what is the CSED? What is the date that the government no longer has a right to collect? It's mission critical to understand that. So hope that you found this helpful, and I'll catch you guys in the next video. Okay, thanks a lot. Bye-bye.